So hello everyone, we are going to discuss AIB 16 previous year question paper. We have already done up till question number 15, AIB previous question, AIB 15 up till 15, and this is AIB 16, and we are going to just try to find out the right options of each question. So what AIB 16 was held in October 2021. It is set D, by the way. So that's how we have to find out the and tick the right answers of it. What question number one say? If a party who obtained an order for leave to amend pleading does not amend the same within how many days, he shall not be permitted to do that without the leave of the court. Option we have 15 days, 14 days, 20 days, or 30 days. The right option of question number one is option B, that is 14 days. I'm going to repeat the question once again. If a party who obtained an order for leave to amend the pleading does not amend the same within how many days, he shall not be permitted to do that without the leave of the court within 14 days. Question number second. Punishment of advocates for misconduct has been given under section of the under dash section of the Advocates Act 1961. Sections options we have section 30, section 32, section 35, section or none. The right option is option C, that is section 35. Question number 3. A company wishes to ensure that no one else can use their logo. A company wishes to ensure that no one else can use their logo. Option have copyrights, trademark, patent, industrial design. The right option is option B, that is trademark. Question number 4. The section of the Arbitration and Conciliation Act dealing with the time of commencement of arbitral proceeding is section 20, 21, 22. Right of or none of the above. Right option is option B, that is section 21. Question number 5. The payment of compensation to railway employees by the Railway Administration for injury by accident is governed by options we have the Employees Compensation Act 1923, B. The Payment of Wages Act 1936, C. Rights of Persons with Disability Act 2016, D. The Workmen Compensation Act 1986. The right option on question number 5 is option A, that is the Employees Compensation Act 1923. Question number 6. The minimum amount of compensation payable under Employees Compensation Act 1923 is case of total permanent disablement of a railway servant due to accident is rupees 80,000, 90,000, 1 lakh, 40,000, 1 lakh 20,000. The right option of question number 6 is option C, that is 1 lakh 40,000. Question number 7. The bond under section 109 CRPC as security for good behavior from suspected person can be executed for a period not exceeding option A 6 months, option B 2 years, option C 1 year, option D 3 months. The right option of question number 7 is option C, that is 1 year. Question number 8. The maximum limit of rupees 500 that could be paid to the wife as as maintenance under section 125 of CRPC 1973 was removed in option 1973, 1989, 2001, 2007. Right option of question number 8 is option C, that is in 2001. Question number 9. The term WIPO stands for option A, World Investment Policy Organization, option B, World Intellectual Property Organization, option C, Wildlife Investigation and Policing Organization, option D, World Institute for Prevention of Organized Crime. Right option of question number 9 is option B, that is World Intellectual Property Organization. Question number 10. The committee which led to the passing of the Criminal Law Amendment Act 2013 was headed by options Justice Dalveer Bhandari, option B, Justice Altamas Kabir, option C, Justice J.S. Verma, option D, Justice A.S. Anand. The right option, question number 10, is option C, that is Justice J.S. Verma. Question number 11. Under the scheme of Criminal Procedure Code, non-cognizable offences are options we have public wrongs, option B private wrongs, option C both public and private wrongs, option C now option D none of the above. The right option of question number 11 is option B. B, that is private wrongs. So under the scheme of Criminal Procedure Code, non-cognizable offences are private wrongs. Question number 12. Or discrimination against a man or a woman only on ground of dash would be violative of Article 15, Clause 1. Options we have sex, option B remuneration, option C place of birth, option D religion. The right option of question number 12 is option A, that is on basis of sex. Question number 13. What is meant by procedural ultravirus? Options we have it is non-observance of the procedural norms by the rule making authority. Option B, it may make the rule ultra-vires due to non-observation of rule making authority and hence become void. Option C, it means the lacuna in the procedure of law. Option D, A and B both. Right option is option D, that is A and B both, means it is the non-observation of the procedural norms by the rule making authority of and B, it may make the rule ultra-vires due to non-observation of a rule-making authority and hence beyond become void. Question number 14. The ground of error of law apparent on the face of the record is connected with which of the writ? Options we have option A, quo warranto, option B, mandamus, option C, habeas corpus, option D, certiorari. The right option on question number 14 is option D, that is certiorari. The ground of error of law apparent on the face of the record is connected with the with which writ? Error of law apparent on the face of the record. Question number 15. Under Civil Procedure Code, find the incorrect match. Section 5, Revenue Code. Section 7, Provisional Small Causes Code. Section 9, Pecuniary Jurisdiction of Courts. Section 8, Presidency Small Cause Codes. Right option of question number 15 is option C, that is Section 9, Pecuniary Jurisdiction of Courts. Question number 16. The objective resolution adopted by the Constituent Assembly on 22nd January 1947 was drafted by options we have Jawaharlal Nehru, option B Dr. B.R. Ambedkar, option C Rajendra Prasad, Dr. Rajendra Prasad, option D, that is B.N. Rao. Right option is option A, that is Jawaharlal Nehru. Objective resolution adopted by Constituent Assembly on 22nd January 1947. Question number 17. Right to the property was eliminated from the list of fundamental rights during the tenure of options. We have Indira Gandhi, option B Charan Singh, option C Rajiv Gandhi, option D Morarji Desai. The right option question number 17 is option D, that is option D, that is Morarji Desai. Question number 18. When the accused states, I will produce the share which I gave received in such and such robbery, which of the following are not admissible with regard to Section 25 of Indian Evidence Act? Point number 1, an admission that there was a robbery. Second point, an admission that the accused took part in it. Third, an admission that he got part of the property. For a statement as to where the property is. Option we have 1, 2 and 3 option. We have third and fourth, option C, which is second, third, and fourth, option D, all of them. The right option is option A, that is first, second, and third. So, what first, second, third says key an admission that there was a robbery, an admission that the accused took part in it, an admission that he got part of the property, and will not include fourth, that is a statement as to where the property is. ये include नहीं है इसमें. Question number 19. Under which section of IPC professional negligence is often evoked against medical professionals in cases alleging professional negligence? Options we have 303A, 304A, 302, 305. Right option is option B, that is 304A. Question number 20. A offers a bribe to be a public servant as a reward for showing A some favor in the exercise of B's official functions. B accepts the bribe. B accepts the bribe. Options we have. Option A has abetted the offence defined in section 160 IPC. Option B, A has abetted the offence defined in section um, 161 IPC, 162 IPC, 163 IPC. Right option of question number 20 is option B, that is A has abetted the offence defined in section 161 of IPC. Question number 21. When perpetual injunction may be granted, perpetual injunction may be granted. Options we have where the defendant is trustee of the property for the plaintiff. Option B, where there is no standard for ascertaining the actual damage. Option C, compensation in money would not afford adequate relief. Option D, all of the above. The right option is option D, that is all of the above. Question number 22. In case of land acquisition by the central government for public, private, or partnership projects, consent of law, consent of how many affected families is mandated by the LARR Act. Options we have 60%, 70%, 80%, 90%. The right option is option B, that is 70%. Question number 23. A company which is not a domestic company will pay income tax at the rate of options 25%, option B 30%, option C 40%, option D 20%. The right option of question number 23 is option C, that is 40%. Question number 24. Amount of deduction under section 24 of the Income Tax Act from annual value is option A, half of annual value, one third of annual value, third tenth of annual value, or 17th tenth of annual value. Right option is option C, that is third tenth of annual value. So amount of deduction under section 24 of the Income Tax Act from annual value is third tenth. Question number 25. The test of reasonableness, the test of reasonableness is not wholly dash test, and its contours are fairly indicated by the constitution, subjective, objective, descriptive, or summative. Right option is option A, that is subjective. So the test of reasonableness is not wholly subjective test, and its contour contours are fairly indicated by a constitution. Question number 26. The power to enact a law relating to the citizenship of India is left to dash under provisions of Article 11 of Indian Constitution. Options we have option A, President, option B, Council of Ministers, option C, House of People, option D, Parliament. Right option is option D, that is Parliament. Question number 27. An arbitration proceeding is a option A, judicial proceeding, quasi-judicial proceeding, administrative proceeding, D, none of the above. Right option is option B, that is quasi-judicial proceeding. Question number 28. What is ad hoc arbitration? Options we have. It is a proceeding administered by the parties themselves with rules created solely for that specific case. Option B. Parties make their own arrangement with respect to all aspects of the arbitration, including the laws and rules. Option C. The seal of arbitration, the language, and the scope of issues to be resolved by means of arbitration. Option D. A, B, C means all of them. Means all of them. Its right option is option D, that is all of them. Question number 29. Which of the following sections of the Civil Procedure Code define the mesne profit? Options we have option A, section 2, subsection 4, section 2, subsection 14, section 2, subsection 6, section 2, subsection 12. The right option of question number 29 is option D, that is section 2, subsection 12. Question number 30. An advocate is under an obligation to uphold the rule of law and ensure that public justice system is enabled to function and at its full potential. Any violation of the principle of professional ethics by an advocate is unfortunate and unacceptable. Ignoring even a minor violation misconduct militates against the fundamental foundation of the public justice system. It was said in option A, Hikmat Ali Khan versus Iswar Prasad Arya, O.P. Sharma versus High Court of Punjab and Haryana, L.D. Jack Wall versus State of Uttar Pradesh, Shamsher Singh Bedi versus High Court of Punjab and Haryana. The right option on question number 30 is option B, that is O.P. Sharma versus High Court of Punjab and Haryana 2011 6 SCC 86. Question number 31. Section 8 of Companies Act 2013 contains provision relating to options we have incorporation of company, option B formation of companies with charitable objects, etc. Option C effect of registration, option D effect of memorandum and articles. The right option of question number 31 is option B, that is formation of companies and charitable objects. Question number 32. The verification of the registered office the verification of the registered office shall be furnished to the registrar within a period of dash incorporation, 30 days, 60 days, 90 days, 120 days. The right option is option A, that is 30 days. Question number 33. Cyber law deals with all activities concerning the internet, IPR, that is intellectual property right, I guess. Option C, e-commerce. Option D, all of the above. The right option of question number 33 is option D, that is all of the above. Question number 34. As per section 53 of IPC, the word injury denotes any harm, whatever illegally caused to any person's option, body, mind, reputation, or all above. Right option is option D, that is all of the above. Question number 35. Which of the following cases can be cured under section 465 of the Code of Criminal Procedure 1973? Options we have entertaining the complaint without complying with section 195 and 340 of the CRPC. Option B, the reading and recording of the evidence taken in one case into another companion case. Option C, the examination of witness in absence of the accused. Option D, non-compliance with section 235 subsection 2. The right option on question number 35 is option B, that is the reading and recording of the evidence taken in one case into another companion case. Question number 36. Which of the following statements hold true for de novo trials? Options we have omission or illegality in the procedure, even if it does not affect the core of the case, can become a ground for calling de novo trials. Option B, a de novo trial should be the last resort. Option C, the court originally trying the case can order de novo trial. Option D, none of these. The right option, question number 36, is option B, that is, a de novo trial should be the last resort. Question number 37, the phrase file a PIL ostensibly in public interest but in fact to serve personal or private interest means options we have filing PIL for protection of only public interest. Option B, filing PIL for protection of both public and private interest. Option C, filing PIL for protection of only private interest. Or option D, that is filing PIL alleging it to be in public interest but actually seeking protection of private interest. Right option, question number 37, is option D, that is filing PIL alleging it to be in public interest but actually seeking protection of private interest. The file a PIL ostensibly in public interest but in fact to serve personal or private interest means. Next question, question number 38. Filing of frivolous PILs results in options we have increasing backlog of cases. Option B, wastage of resources. Option C, lesser availability of time for hearing other genuine cases. Option D, all of the above. Right option is option D, that is all of the above. Question number 39. Z, under the influence of madness, attempts to kill X. Is Z guilty of an offense? Is Z guilty of an offense? Has X the same right of private defense which he would have if Z were sane? Has X the same right of private defense which he would have if Z were sane? Options we have: Z has not committed any offense as per section 98 of IPC, and the same right of private defense to X and same right of private defense to X if Z is mad. Option B, as per section 98 of IPC, X has committed an offense and no right of private defense to X. Option C, Z has committed an offense for not using his mind. Option D, none of the above. The right option is option A, that is Z has not committed any offense as per section 98 of IPC, and the same right of private defense to X is also available, whether uh, apart from the fact that Z is mad. So the X have the same right which he would have, the right of self defense to protect himself in place of that mad person. If there would be any other person, then also there would be the same right. मतलब कि ये मैड व्यक्ति है और ये एक नॉर्मल व्यक्ति है और ये है एक्स, तो जो राइट सेल्फ डिफेंस के लिए, दिस वाज मैड एंड दिस वाज नॉर्मल, जो राइट इसके पास नॉर्मल पर्सन के लिए है सेल्फ डिफेंस के लिए, वही सेम राइट इसके लिए मैड पर्सन के बिहार, मतलब उसके अपोजिट भी सेम राइट होगा सेल्फ डिफेंस का, मतलब दोनों ही केस में सेल्फ डिफेंस कर सकता है। ये फैक्ट मैटर नहीं करता है कि ही वॉज मैड। Question number 40. Admission can be broadly categorized into judicial, extrajudicial, either A and B. Option D, both A and B. Question number 40. Right option is option D, that is both A and B, means judicial and extrajudicial. Admission can be broadly categorized into judicial and extrajudicial. Question number 41. Section 66 Indian Evidence Act lays down options. We have option A notice must be given before secondary evidence can be received under section 65A Indian Evidence Act. Option B, notice to produce a document must be in writing. Option C, order 11. Rule 15 of Civil Procedure Code prescribes the kind of notice to produce and document. Option D, all of them. The right option of question number 41 is option D, that is all of them. So, Section 66 of Indian Evidence Act lays down a notice must be given before secondary evidence can be received. Under Section 65A of Indian Evidence Act, notice to produce a document must be in writing. Option C, Order 11, Rule 15 of CPC prescribes the kind of notice to produce produce a document. The light has been just disappeared, or I will say it has been gone, so we have to continue our video. My face doesn't matter at all. Question number 42, Maxim. Res ipsa, res ipsa loquitur means the thing speaks for itself. Where there is right, there is remedy. Where there is remedy, there is right. Where there is no fault, there is no remedy. Right option is option A. The thing speaks for itself. Res ipsa loquitur. Res ipsa loquitur. Question number 43. What is the period of limitation? What is the period of limitation for expeditious disposal of suit under Specific Relief Act? What is the period of limitation for expeditious disposal of suit under Specific Relief Act 1963? Options we have 6 months, 10 months, 12 months, 18 months. Right option is option C, that is 12 months. Question number 44. A chief judicial magistrate may pass a sentence of imprisonment. Options we have not exceeding 7 years. Option B exceeding 7 years. Option C for life. Option D none of the above. The right option is option A, that is not exceeding 7 years. Question number 45. The maximum limit of members of the State Bar Council is 15, 20, 25, none. Right option is option C, that is 25. Question number 46. The Specific Relief Act 1963 contains 6 chapters and 40 sections, 7 chapters and 42 sections, 8 chapters and 43 sections. Option D, 8 chapters and 44 sections. तो इसका right option होगा option D, that is section that is 8 chapters and 44 sections. इसमें अगर यहाँ पर 8 chapters and 42 sections होता तो ये ना करेक्ट होके ये करेक्ट हो जाता, बट यहाँ पर ओनली 7 चैप्टर मेंशन है, तो चैप्टर तो टोटल 8 है ही, उसके अलावा जो सेक्शंस हैं लास्ट के दो आप देखेंगे 42 था केवल, 43 एंड 44 ओमिटेड है, तो यहाँ पर ये चैप्टर 7 है इसलिए यहाँ पर ये गलत हो जाता है। सेक्शन तो 42 ही हैं आई गेस, है ना, मतलब 42 तक सो होते हैं, हो सकता है उसमें और भी ओमिटेड हो। तो इसका राइट आंसर है ऑप्शन डी, दैट इज 8 चैप्टर्स एंड 44 सेक्शंस। Question number 47. Any private person may arrest any person who, options we have, commits non-bailable offense in his presence, non-bailable offense in his presence. Option B, commits non-bailable offense and cognizable offense in his presence. Option C, commits compoundable offense in his presence. Option D, commits offense in his presence or is a proclaimed offender. So its right answer would be option D, that is commits offense in his presence, कि अपराध करता है, doesn't matter कि बेलेबल है कि नहीं है, कंपाउंडेबल है कि नहीं है, अपराध करता है और या तो उसके बारे में कोई अपराधी हो, घोषित अपराधी हो, तो उन दोनों ही केस में कोई भी नॉर्मल पर्सन जो है उसको डिटेन कर सकता है, उसको पकड़ सकता है। क्वेश्चन नंबर 48. How long a warrant of arrest shall remain in force? Option we have 6 years, option B 10 years, option C 12 years, option D until executed or cancelled. Its right answer option is option D, that is until executed or cancelled. मतलब कोई फिक्स ड्यूरेशन नहीं होता है कि इतने बाद जो वारंट है वो अपने आप कैंसिल हो जाएगा, रिवोक हो जाएगा। ये तब होगा जब या तो वारंट जो है उसको एग्जीक्यूट कर लिया गया हो, मतलब वो जो अपराधी है जिसके लिए वारंट रिलीज हुआ है, वो ऑर्डर पास हुआ है, तो या तो वो पकड़ा जाए अनटिल एग्जीक्यूटेड, या तो वो ऑर्डर जो है कैंसिल कर दिया जाए, कोर्ट जिस कोर्ट ने उसको इशू किया है उन्हीं कोर्ट के थ्रू। तो ऐसे दोनों केस में वो जो वारंट है वो एग्जीक्यूशन में रहेगा या फिर कैंसिल हो जाएगा, अदरवाइज उसकी कोई लिमिट नहीं होती है। क्वेश्चन नंबर 49, रेट ऑफ एडिशनल depreciation will be under section 32 of Indian Income Tax Act of the depreciation percentage. Option we have 10%, 20%, 30%, sorry, 15% or 30%. Right option is option 49, that is the right option of question number 49 is option D, that is 30%. Sorry, not 30%, but 20%. 20%. So rate of additional depreciation will be under section 32 of Income Tax Act is 20%. Question number 50, the rule of strict liability. The rule of strict liability is based on decision in options we have Dono versus Stevenson, option B Holmes versus Ashford, option C Raylands versus Fletcher, option D none of the above. Right option is option C, that is Raylands versus Fletcher. This case is based on the rule of strict upon the rule of strict liability. Raylands versus Fletcher. Question number 51. The rule of last opportunity was laid down in device versus man, option ma or man. Device versus man. Option B. State of AP versus Rangana. Option C. Newgate versus Smith. Option D. Kalavati versus State of Himachal Pradesh. Right option is option A, that is device versus man. Question number 52. In which of the following cases was it held that the right conferred under Section 25 of the Hindu Adoption and Maintenance Act 1956 supersedes any contract to the contrary? The fact that the date of decree makes no difference. Options we have Surendra Bal versus Supia. Option B. Mukesh Teli versus Bharti Teli. Option C. Sesi Amal versus Thayu Amal. Option D. Lakshmi versus Krishna. Right option of question number 52 is option C, that is Sesi Amal versus Thayu Amal. Question number 53. Which of the following sections of Hindu Adoption and Maintenance Act 1956 deals with amount of maintenance? Options we have section 21, section 22, section 23, section 24. Right option of question number 53 is option C, that is section 23. Question number 54. In which of the following case the Supreme Court first of all made an attempt to look into the question regarding the extension of the right to life to the right to health and other hygiene conditions? Options we have the Rural Litigation and Entitlement Kendra versus State of Uttar Pradesh. Option B MC Mehta versus Union of India. Option C V Lakshmipati versus State of Karnataka. Option D FK Hussain versus Union of India. The right option of question number 54 is option A, that is the Rural Litigation and Entitlement Kendra versus State of Uttar Pradesh. Question number 55. Basel Convention is associated with one of the following. Options we have option A, international trade in endangered species of wild fauna and flora. Option B, climate change. Option C, protection of ozone layer. Option D, the control of transboundary movement of hazardous waste and their disposal. Right option of question number 55 is option D, that is the control of transboundary movement of hazardous waste and their disposal. Question number 56. Cybercrime is dash in nature. Options we have tangible, intangible, of mental violence. Option C, none of the above. Tangible is जो टच कर सके, intangible जो can't be touched, of mental violence. So Its right option is option B, that is intangible, that can't be touched, means kind of mentally kind, ये भी इसी में involve हो जाएगा ऐसे. This will include this also, but not only this. So question number 57. Recovery of a specific immovable property may be obtained by CPC within what period? Within 7, within 6, within 8, within 10. Right option is option B, that is within 6 months. Question number 58. Who appoints the Commissioner for Rehabilitation and Resettlement under LARR Act? Options we have LARR Authority, option B, that is Minister of Environment and Forest, option C, Central Government, option D, State Government. Right option is option D, that is State Government. Question number 59. A plaint has to be presented to the court under Order 6 Rule 1. Under Order 6 Rule 1, in option we have single copy, option B duplicate, option C triplicate, option D no fixed rule. Right option is option B, duplicate. So a plaint has to be presented to the court under Order 6 Rule 1 in duplicate. Wait, let's see the question number 60. Where is the pen? Omission to give notice under Order 21, Rule 22 will, option we have, render the execution null and void, render the execution irregular, render the execution voidable, or option D, that is not affect the execution. Right option question number 60 is option A, that is render the execution null and void. Question number 61. Where a decree is passed against the Union of India or state of the act done in the official capacity of the person concerned under section 82 CPC, execution shall not be issued on any such decree unless the decree remains unsatisfied for a period of, options we have, 3 months from the date of decree, 6 months from the date of the decree, 1 year from the date of the decree, 2 years from the date of the decree. Right option of question number 61 is option A, that is 3 months from the date of the decree. Question number 62. The Hindu Marriage Act 1955, petition in which a decree of restitution of conjugal rights has been passed to apply to the court for a decree for divorce by showing that there has been no restitution of conjugal rights as between parties of marriage for a period of 1 year or upwards after passing of the decree. Option B have, does not permit any party to that. Option B, does not permit the party against whom the I don't know, इसको कहाँ से कंटिन्यू करेंगे. Does not permit the party against whom. Option C, does permit any party to that. Okay, यहाँ पे है ना ये, whom the petition in which a decree of restitution of conjugal right has been passed to apply, and so does permit any party to that. Option D, that does permit any person related to either party to that. Right option of question number 62 is option C, that is does permit any party to that. Question number 63. The offences under the Prohibition of Child Marriage Act 2006 are, option A, cognizable and bailable, option B, non-cognizable and non-bailable, option C, cognizable and non-bailable, option D, non-cognizable and bailable. Its right option is option C, that is cognizable and non-bailable. Question number 64. Protection against arrest and detention in certain cases is mentioned in which of the following articles of Indian Constitution? Option A, Article 21. Option B, Article 21A. Wait, 19 से 22 तो है राइट टू फ्रीडम, राइट टू फ्रीडम, ये है राइट टू लाइफ 21। इसमें पूछा क्या है? प्रोटेक्शन अगेंस्ट अरेस्ट एंड डिटेंशन इन सर्टेन केसेस इन विच मेंशन डिटेंशन। 21 ए होगा आई गेस, बी देखना पड़ेगा। आर्टिकल 22 और ऑप्शन डी दैट इज आर्टिकल 22 ए। राइट ऑप्शन ऑफ क्वेश्चन नंबर 64 इज ऑप्शन सी दैट इज आर्टिकल 22। राइट ऑप्शन इज ऑप्शन सी दैट इज आर्टिकल 22। Question number 65. Article 300A of Indian Constitution, that is right to property, has been inserted in the Constitution by option 44th Amendment Act, 42nd Amendment Act, 40th Amendment Act, 51 Amendment Act. Right option is option A, that is 44th Amendment Act. Question number 66. Which of the following sections of the Muslim Personal Law Shariat Application Act 1937 have been repealed, amended by Section 6 of Dissolution of Muslim Marriage Act 1939? Right option is Section 4, Section 5, Section 6, Section 7. Sorry, option we had, and the right option is option A, that is under Section 4. Question number 67. On which of the following dates did Hindu Marriage Act 1955 come into operation? Option A, 18th May 1955. Option B, 17th June 1955. Option C, 22nd May 1955. Option D, 18th June 1955. Right option of question number 67 is option A, that is 18th May 1955. Question number 68. Which of the following properties will Section 30 of the Hindu Succession Act 1956 govern? First, Tarwad, Tawazi, Kutumba, Kavaru, Ilom. Options we have first, third, fifth, second, fourth, fifth, first and second, all of the above. Right option is option C, that is first and second, which is Tarwad and Tawazi. Question number 69. Freedom of residence under Article 19 of that Indian Constitution is available in which of the following clause? Option A, clause 1, clause 1, subclause E, clause 1D, clause 1B, or clause 1C. Right option of question number 69 is option A, that is clause 1, subclause E. Question number 70. Under which section of the Evidence Act, of course, Indian Evidence Act, admissions are defined? Under section 17, 16, 15, or 18? Right option is option A, that is under section 17. Question number 71. In which of the following cases the Supreme Court has held that the investigating officer should be allowed to refer to the records of investigation? Options we have state, um, चलो इसको कंटिन्यू करते हैं। 71 है ना, तो 70 तक हो गया है, तो इसको नेक्स्ट पार्ट में कंटिन्यू करते हैं।